Resuming debate, reprise du débat. The honourable member from Toronto-Danforth.
Monsieur le Président.
Thank you, Mr. Speaker. I will be splitting my time with the member for with one of the honourable members, so we'll be doing 10 minutes each.
And that the title of the bill, quite obviously, is something that should give us pause. The reference to foreign criminals is something that seeps throughout the entire bill, and that, if we're not careful, could help construct society's understanding of the contexts that are being discussed in the bill in a way that separates those of us who are lucky to have full citizenship with those amongst us who are merely landed immigrants or permanent residents. I'd like to come back to that point when I discuss a bit later the cutting off of appeal options in new categories of cases. But I do want to put on record that one of the biggest problems is almost a discursive problem by the reference to foreign criminals in this undifferentiated way in the title. Second big problem with the bill, Mr. Speaker, is that in some ways it combines two extremes. One extreme, two extremes in terms of the exercise of state power in this context. One extreme is that it gives a full, at least in terms of the text, an unfettered discretion to the minister on one hand with the new Section 22(1) that allows him or her to refuse temporary residence visas on his or her own opinion of what are public policy considerations. There's nothing in the bill that talks about any constraints on that. We had an answer earlier in the House from the Parliamentary Secretary that suggests that the government might be open to giving a little bit more substance to that, but at the moment it's not in the bill. On the other hand, we have no discretion at all on other fronts in the bill in a way that adds to the repressive dimensions of its structure. There's a new, within Section 64, which changes the threshold for no appeal rights after being determined to be inadmissible from 2 years to 6 months, removing the appeal as of right. There's nothing in between. There's no procedure for a leave to appeal. It's all or nothing. If you've been convicted for an offense that has involved imprisonment of 6 months, then you have no right of appeal from the decision on admissibility to the Immigration Appeal Division. On the other hand, as well, in terms of no discretion, there's a new Section 25 wording that removes not just the right of the minister, but the power of the minister to consider humanitarian and compassionate considerations in a category of cases. Now, I want to be careful here when I add this in as a problem, because those category of cases are worded very broadly, and they seem like the kind of cases when you would never want to exercise discretion to allow somebody to stay. Security, organized criminality, and human and international rights violations are the words used. But even within those categories, they're so generally worded, organized criminality, security, that it's not difficult to imagine some circumstances in which there may be reason to lighten the severity of the law and allow somebody to stay. And that, in fact, is how the system has worked. On occasion, the minister does exercise exactly that discretion for those reasons. The fact is that's been eliminated. So we have to look very carefully when this does hit committee as to whether or not the use of extremes, nothing in between, has actually created a bill that will, down the road, show itself as producing a lot of hardship. I'm going to primarily address the question of the reduction of the elimination of the right to appeal for a broader category of persons, and also the public policy discretion of the minister. With respect to that public policy discretion, let me start there. The new Section 22(1) says, the minister may, on the minister's own initiative, declare that a foreign national may not become a temporary resident if the minister is of the opinion that it is justified by public policy considerations. and he may do that, or she may do that, for up to 36 months. That's it. That's all we have there. It's not too difficult to imagine how, in the hands of a certain minister or a certain period of time, this could be exercised very arbitrarily, if not abusively. There's nothing in the bill to constrain that, other than, I hope, the fact that there would be judicial review available, but judicial review is one of the worst possible ways to produce checks in any legal system because it requires time and money and good lawyers to actually get anywhere. You need to have a system of decision-making within the bill itself that checks the minister in his or her decision-making. And public policy considerations is just simply far too broad a mandate to give any one person to exercise in the context. I won't go into specific examples, Mr. Speaker, but we do know of at least a few examples where the Minister of Immigration has clearly not wanted somebody to enter the country for reasons that under the surface appear to be more about politics than they do about sound public policy. I really think that that clause has to be looked at in committee. It has to be beefed up if it's going to be retained. The next provision to look at is Section 64, which, as everybody has noted, lowers the threshold for removing the right of appeal on an inadmissibility decision from 2 years imprisonment to 6. So if you've been imprisoned for 6 months, then that's it in terms of you having any right of appeal. You don't have any. Now think about some of the things that are in the criminal code that can attract 6 months. They may not that often. Stealing oysters, Section 323, selling a betting pool, Section 202. The list actually goes on. There are lots of offenses that can attract 6 months. We'd like to think that the system would never end up seeking to deport somebody for these kind of offenses, but the moment we go down from 2 years to 6 months, we actually enter that territory where these kinds of Kafkaesque possibilities are actually there. What about more recently, the effects of mandatory minimum legislation in Bill C-10? Well, we know now that with marijuana, for example, production of 6 plants, growing of 6 plants, can lead to a 6-month sentence. The sentence cannot exceed 6 months, but can also be 6 months in the new Bill C-10 when that takes effect in the criminal code. 6 months, 6 plants, no appeal. Does that seem at all proportionate, Mr. Speaker, to the kind of more nuanced decision-making that we would want our law to recognize? Hopefully, that would never be used as the basis by the system to seek to deport somebody in and of itself, but there's nothing protecting against that result the way it is written. But the biggest problem is that the lower the threshold, the more people are going to be caught by it, the more people who have permanent residence or landed immigrant status are suddenly going to be put in this category of deportable, even though what they've done in the grand scheme of things is not nearly as serious as what used to be the case under the law. We have to begin to reflect on how much ownership we have to take of those amongst us who get into criminal trouble, who do end up with sentences, say, right at the edge of 6 months, 8 months, 9 months. Who's responsible? What society is responsible for dealing with that issue? Is it always the other country that has the formal nationality, a country that a person may have not seen in 30 years, a person who may have come here at age 2 or age 3, doesn't even speak the language of the other country, for example? Or is it the country where the person grew up and basically produced the conditions under which the crime occurred? We're not responsible for it, but we are that person's brothers and sisters. How do we think about the fact that the lower the threshold is, the more likely it is that people amongst us will end up in the let's put it this way, in the headlights of the minister or the Ministry of Immigration for this kind of deportation? So what I would like to say in closing, Mr. Speaker, is that in its most general sense, this bill may not appear offensive to those on the other side or to many in society. But when you look at how minimal the trigger is for somebody to be deported with no right of appeal, we really have to question whether this is the way our society wants to go. 2 years itself is already something that was a compromise. Why we've gone to 6 months has escaped me. Thank you so much, Mr. Speaker.
Questions and comments?